court. My name is George Paris, and I am the presiding judge. Forgive me for reading, but there are certain points I must cover, and I want to be sure that I do. How many of you have been jurors before? Okay. The trial you are attending has been called by the court, and you will be acting as a part of the judicial branch of our constitutional government. For some of you, this will be the first time you have been called to this important service. It is a constitutionally guaranteed right of every citizen to have the facts concerning his or her claim and defense heard, weighed, considered, and determined by a jury of his or her peers. It is important to the plaintiff and the defendant that you willingly and without reservation determine to do your duty as jurors in accord with the highest and truest sense of obligation. You will receive $20 a day if you appear and $40 if you are selected to sit as a juror, and your travel expenses at the rate of 40 cents per mile. At the conclusion of the trial, a list will be prepared and submitted to the county auditor. You should receive your check soon after the trial is ended. In order that you know the court personnel with whom you will be working and their respective duties, the court reporter is Paul Georgie, and he takes down everything that is being said in the courtroom and electronically transcribed, including the statements that I am now making. The questions that you will be asked, your answers, and all other matters in this case. Mr. Georgie will monitor and operate the machine and is the keeper of the exhibits. The bailiffs are Ron Williams and Michael Shirelli. They enforce the court's orders and have charge of the jury while it is away from the courtroom. If you desire at any time to ask about any matters about your personal welfare apart from the case that is being tried, you should ask one of the bailiffs who will handle the matter. Some of you may need statements to verify your services as jurors for your employers. The bailiff will furnish forms to you as needed. At this point, I would like to tell you that we expect this trial to last 3 days. Maybe three and a half. I will certainly describe the procedure where some of you will be selected for actual service as jury members in this case. All of you will be asked to take an oath or affirmation that your answers will be truthful. I will ask a number of questions addressed to all of you as a group. If any of you desire to answer yes to any of these questions, you should raise your hand at the time the question is asked. After I have finished, the lawyers for the parties will question you. These questions are not supposed to be offensive, nosy, personal, or prying. They are necessary to make sure that a jury should be made up of people who can fairly and impartially carry out their responsibility. You understand, any person having knowledge of the case or the parties might not be eligible or not be able to be fair and impartial. Any of you may be excused. You should not be offended if you are excused for no apparent reason. Each lawyer has a certain amount of what we call strikes. At this time, it is necessary for me to administer the oath or affirmation to all of you. Will you all stand, raise your right hand, and be sworn? Do you swear or affirm that you will honestly answer any questions asked of you during jury selection? All right, you may be seated. Is there anyone here who would have any problems sitting on a jury, such as scheduled vacations, babysitters for children, a ride to the courthouse, a hearing, eyesight problem or condition, language difficulty, or anything that you would like to bring to my attention? When you hand your back, give me your jury number, then tell me what. Oh, okay. Any of you have, all right, let me go over it again. Is there any person here who had any problems sitting on a jury, such as scheduled vacations, babysitters for the children, a ride to the courthouse, a hearing or eyesight problem or condition, language difficulty, or anything that you would like to bring to my attention? Okay. Anyone else?
Does that include medical? Any kind of medical?
Yes, ma'am. What's your problem?
Well, I was away when I got the summons, and I didn't get the opportunity to go to my doctor, and I had bad problems. I had place spasms where I can't sit for a very long time, and that concerned me that I
You have to stand at times and... Right. Your leg falls, gets numb?
Yes, I've got my medication.
Okay. Gentlemen?
I did not have time to pay back.
Counsel?
No, sir. I have no objection.
And we're going to excuse you. You're free to go.
C92.
What was your number again?
92.
C92. Okay.
C52,
Yes, ma'am.
venous insufficiency with severe stomatitis, which caused my legs to swell. I said too long.
Gentlemen.
No objection. No objection.
You're excused, ma'am.
C9, I just have doctor appointment.
Well, is it something you can reschedule? Okay, is it for a condition that needs immediate attention, or?
No, just my blood surface and
Okay, so it's just a checkup?
yeah, well, yeah, more or less.
All right, well, let's see, maybe we can reschedule that.
All right.
All right.
I've already postponed it once. I'm going to go to school and so I'm looking at and my brother's coming up getting close to so that 3 days will take me I've already postponed it. Especially going to go
Okay.
I have no objection.
All right,
I'm here, Your Honor.
we'll excuse you.
Extremely bad hearing and enlarged prostate condition.
Okay.
Very little of what's been going on in the OPM with here.
Can you hear me now?
Fairly well, yeah.
David? I didn't hear the last part. I said that large prostate or something after that.
Is a hearing problem.
Very problem, bad hearing. Very good.
I have no objection.
No objection.
All right, so you can go. Is that all? All right. You have been summoned here as jurors in the case of, well, let me just find it. Glendale Harris versus St. Mary Medical Center, Inc. Counsel, should I read from this, or should I go to pretrial or read the contentions? Is this what you...
Read preliminary
All right,
instructions.
all right. Plaintiff Karanda Harris contends as follows. In this case, Plaintiff Karanda Harris has sued defendant St. Mary Medical Center. Plaintiff Karanda Harris contends as follows. On October 1st, 2009, she was a patient of defendant in its outpatient physical therapy department located by defendant's hospital in Hobart, Indiana. Plaintiff contends that she had been a patient since October 13, 2008, and she was learning to walk again following a significant surgery for cancer. As she was walking the track at defendant's physical therapy facility on October 1st, 2009, using a four-pronged cane, plaintiff tripped and fell on carpeting that was negligently placed on the walking deck by defendant. Plaintiff contends the defendant was negligent in causing her fall because, among other things, the carpet should not have been on the walking track. It rendered the premises hazardous. In addition, plaintiff contends that defendant was negligent because it allowed her to walk on the track and even encouraged her to walk alone without assistance of a therapist or assistant physical therapist, all contrary to requisite standard of care. Plaintiff further contends that as a result of defendant's negligence, she fell and fractured her hip. She required surgery, the installation of hardware in her body, and that she sustained permanent injuries. At the time of plaintiff's fall, she had progressed significantly in her rehabilitation and her ability to walk and care for herself without assistance. Because of her fall and injury, plaintiff's progress was for naught, and she was basically reduced to the same point she was when she began therapy about a year earlier. Plaintiff also endures significant physical and emotional pain and will in the future because her injuries are permanent. She also incurred significant medical expenses for treatment and care for injuries caused by the defendant. Negligence and will in the future. Plaintiff must prove her claims by a greater weight of the evidence. Defendant is not required to disprove plaintiff's claims. St. Mary Medical Center Inc. contends as follows. It denies that it was negligence or that it did anything wrong that caused or contributed to Ms. Harris's fall. Defendant contends that its premises were reasonably safe for Ms. Harris' use at all times, that it complied with the standard of care in delivering physical therapy service to Ms. Harris, that before the accident, Ms. Harris was specifically instructed to sign in and wait for her therapist when arriving for each therapy appointment, that at the time she fell, Mrs. Harris was walking on the track alone without any supervision or assistance, contrary to those instructions, and that Mrs. Harris was already aware of the rug on the floor before she fell, to fail to exercise reasonable care for her own safety. Defendant also expects to prove that Ms. Harris did not trip on the rug as she claims. Rather, defendant contends that Ms. Harris fell because her right leg became fatigued and gave out while she was walking on the track without supervision or assistance when she was not supposed to be doing so. Finally, defendant does not dispute that Ms. Harris sustained a fracture of the right femur as a result of the fall. However, it does dispute that her fractured leg, subsequent medical expenses, and other injuries and damages that she is now claiming were caused by or reasonably related to any negligent or wrongful conduct of the defendant, by the defendant. Defendant must prove its claims that plaintiff fell because she failed to exercise reasonable care for her own safety by a greater weight of the evidence. At this time, ladies and gentlemen, I would like the lawyers to introduce themselves. For the plaintiff, we have...
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Dave Servant. This is my client, Ron Harris.
Good morning, everybody. My name is Steve Tyler. I represent the hospital. I have with me John Vandenberg from my office. We're representing Crown Point. I have Dion Ott, who is an officer of the hospital.
Okay. Let's see, I need to read the list of the witnesses. Let's see, that's a pre-trial order. Okay. Ladies and gentlemen, the witnesses in this case will be plaintiff Karanda Harris, Anna Marie Basden, Scott Becker, M.D., Austin Hefner, Tabitha White, Tiffany Wolf, Deanna Lebeck, Greg Wolf, Greg Harris, Barbara Garland, Robert Garland, Brooke Yaw, Amber Kimbrough, Tracy Going, Maria Doctor. Are we calling all these people?
No.
Do we know who we're calling?
I think we have a reasonably good idea.
Okay, so you'll go through them all anyway?
I don't think so, with the exception of perhaps Dr. Andrews, Scott Andrews.
Okay.
And Michael Manning.
He's on the defendant's side. Number 29 is witness by deposition.
Okay, now let me, might as well go through. Was that Tagara, Amber, Arthur Aaron Harrington, Carlos DeJesus, Renato Albero, Sashi Bonbati, Rosemary Mondaeno, Kevin Gahan, Susan DeGroat, over Fire Department EMT, Kevin Hagee, EMT, Ray Halton, EMT, Dr. Barut Pompidis, Dr. Scott Andrews, Dr. Mary Carver, Dr. Terrence Peabody, Dr. Valerie Lewis, Dr. Fulton Thompson. Looks like that's it. Okay, let's get to